Good afternoon. Good afternoon, everyone. I'm here to talk today about. Have we got everybody here, or should I wait for a few minutes? I'll give it another 15 minutes. Today, I'm talking about successfully defending a case under the Negotiable Instruments Act. Now, this is a very important and interesting enactment because traditionally, the issue of dishonor of checks was a civil liability. And if you look back at this legislation, it's the 1881 legislation. It only talked about civil liability for the dishonor of checks. But in our country, we reached a point where, if I may say so, we had a situation where checks had become worthless pieces of paper. Now, when checks become worthless pieces of paper, when they are not useful, when they were not being used at all relevant, the government came out with a strategy, as the government in India is, and a lot of developing countries is apt to do, to create a criminalization of a purely civil action. And the whole purpose was to make the banking sector effective, because people were wary of giving checks. This is the time in the 1980s, as I said, 1988, 89, when if anybody had to do a business transaction, they would say, please give us a demand draft or a pay order, because we don't believe in checks. Checks were really acceptable tender, but not really utilized. Now, this was the situation with checks at that relevant point of time. Having said that, I must tell you, just give me a moment, please. Just give me a moment. I think we're having a little technical issue. Yeah. Is it okay? Huh? You're calling me up. Okay, so that was a little aside. I'll come back to what I was saying. So we reached a point, as I said, the economy is opened up, the government wants to make checks relevant, they want to make checks viable tender, and therefore they bring in this criminalization. And as you will see, in the decades of the 1980s onwards, in fact, really 80s onwards, there has been a greater attempt to criminalize human conduct of various kinds to make it prosecutable. Now, contemporaneous to that is the opening up of the Indian economy. You have now people coming in the financial sector, bank loans, people coming in with vehicle loans, and suddenly the concept of EMIs, equated monthly installments, is coming into being. And the loan market for the individual buyer is becoming more and more accessible. As this becomes accessible, initially, you were only dealing with public sector banks, but private sector banks came in and they wanted to generate or enter this area of business. So checks became very important, because people would take EMIs in advance, and if checks were not going to be dishonored, then nobody was going to use it. One of the unwritten codes in private sector institutions earlier used to be that lawyers, journalists, and police officers are not going to get loans, because there's a question, the problem used to be of recoveries. So one of the first, as I said, attempts in reforming the sector was to bring in this criminalization of section of the Negotiable Instruments Act, and we had sections 138 onwards, till about 142, 143 added, and that was the first amendment. There have been subsequent amendments to these provisions in 1991, in 2002, in 2005, and the last such amendment took place in 2018, which is a jurisdictional amendment. Initially, as I said, the whole idea was to make it a criminal offense, but over the years, this has given rise to so many litigations and so many Supreme Court and High Court decisions. It's actually immense, the amount of decisions that have come, as a result of which we've reached a point where there is a whole body of law, and the criminal justice system, and especially the magistracy which deals with this, was under a burden where it was almost collapsing. The courts, the High Court, Supreme Court, tried to find ways to interpret the Negotiable Instruments Act so as to reduce burden. There were jurisdictional issues. At one stage, the Delhi High Court took a view that these matters could be tried in the Sessions Court. But finally, a view was taken that this is it. No Sessions Court. It can only be a magistrate court because that's the only court, and that was a division bench of the Delhi High Court. So there have been, as I said, a number of issues back and forth. There have been legislative changes to make it a summary trial, to make it more expeditious, to make it effective. And the last such attempt was in Rathor's case, Justice Vikramjit Sen's judgment, where jurisdiction of filing of a complaint was sought to be interpreted. It led to the 2018 amendment, and now we have the amendment which prescribes where jurisdiction will take place, and it is no longer as open-ended as it used to be. So today, with Negotiable Instruments Act, litigation exploding, we have a flurry of lawyers and law firms who just do just this. They do bulk litigation for banks, for people in the financial sectors. But what's happened is, for the criminal justice system, the remedy that is of prosecutions for check dishonor has almost become worse than the problem that it wanted to address. And the criminal justice system, as I said, has been reeling under this load. In fact, Negotiable Instruments Act litigation in the magistrates court is a whole body of litigation, far more perhaps than other categories of litigation. And, the whole purpose was to make it work. Now, one thing we must keep in mind, and this is very important, that the provisions themselves are very simple. It is not that check bouncing is an offense. What is an offense is the failure to pay after a notice is issued in a stipulated period of time. And if you don't pay the money within that stipulated period of time and don't respond, then that's the offense. So really it's the liability to pay that was being focused upon. It's a summary trial. Affidavits can be accepted at the pre-summoning stage. The service through couriers, etc. has been allowed. Delay can now be condoned. And these are compoundable offenses. Earlier, there was a Supreme Court decision which said that compounding ought to be encouraged in such cases. But now the statute, the Negotiable Instruments Act itself has been changed, and that allows for compounding of such offenses. There is a very important presumption. In fact, there are two things which are important. One is, there is a presumption that if I issue a check to somebody and I accept the signature on the check, there is a presumption that I must have issued it in discharge of a debt or a liability, and that check is for consideration. So I have to prove that either there is no debt or liability, or I have to establish that this is taken under fraudulent circumstances, or I was made to sign a blank check, or that it's not my signature. And there are plethoras of defenses which I'll deal in a little later. The defense cannot be that when I gave the check, I did not know it would be dishonored. That defense is not permitted under the legislature. We have a specific provision of that, section 140 of the Negotiable Instruments Act. There are also a provision for vicarious liability, that is in the case of a company, a firm, a trust, a society. You not only prosecute the company, firm, trust, or society, you also prosecute the persons in charge and responsible, or the persons who are actually liable, as in people who signed the check, or in the case of a company, a managing director of a company. I've had occasion to do a fair number of these cases because early on in my career, I got the opportunity to represent some clients, and I have actually had the advantage of seeing the growth of this law in the decade from 2000 to 2010, and there was a vast body of litigation that came out during that period interpreting each provision of the Negotiable Instruments Act. But having said that, I must tell you Nothing much has changed because there is a constant interpretation, because there is so many cases filed in the trial courts. It gives rise to all kinds of challenges, and lawyers, as you know, on both sides are very creative, and therefore there is an attempt to create new and new mechanisms. Now, I must tell you, when you read these sections 138 to now 147, please do not ignore the rest of the Negotiable Instruments Act. That is important because that describes what is a valid negotiable instrument, what's a valid check, the kind of endorsement that can be done, whether there can be cutting, whether there can be tampering, what is the time period, what is the limitation period for these checks, whether there can be an endorsement in blank, endorsement in full. So all of these issues become very, very crucial in a consideration to determine what is the liability under this act. As I said earlier, and I'm going to add a little more detail, in order to attract Section 138, and we need to understand the provision before we can look at defenses, the check must have been issued in discharge of a liability, number one. It must be drawn on a bank account which is owned by the person concerned. It must be signed by the person who's being prosecuted. It must be presented within the period of time. If returned unpaid, notice is to be issued. If notice is not responded to in the stipulated time and payment is not made for the check, then and then only can you launch a prosecution. So this demand of writing within 15 days is very, very important. Of course, there is a limitation also for filing of the complaint, which is 1 month, when the drawer doesn't pay within 15 days of the receipt of the notice. And this becomes very important in a case like this because it's a strict liability offense. Since you can't say I didn't have the knowledge that the check would not bounce or would not be dishonored, therefore the mere dishonor of the check and the failure to pay attracts the offense, and therefore the onus is very high on the accused to prove his or her innocence. This is a summons case. What does that mean? It means it's a summons case. By the new amendment, it is also a summary trial, which means the moment complaint is filed, affidavit is filed, and a summons is issued to an accused, he or she must appear. And once he appears, he or she notice will be framed and the trial will begin. Now, once the trial begins, you then have no other remedy, even in the most greatest case of abuse of process, than to go to the High Court, which is settled in two judgments of the Supreme Court, Adalat Prasad, which is a 2004 decision, and Subramaniam Seturaman, which is 2004, volume 13, SCC, page 324. There is a discordant note taken in a subsequent judgment in Bhushan Kumar, which is of 2 judges, which is the 2012 decision of the Supreme Court. That's not on Negotiable Instruments Act cases, that's on summons cases, but my view is that the principle in Adalat Prasad remains good law. So if you are summoned wrongly, if you have a notice against you framed which you believe is wrong, the only remedy is to go to the High Court and no other court. Now, to come back to our defenses, you would recall I began by saying there is a presumption, and that presumption is under Section 139 of the Negotiable Instruments Act, which places a heavy onus on the accused to show that there is no liability, or otherwise that there is a defect in the check which brings it into a category where it can't be termed a negotiable instrument. And these are, barring this, the other defenses are really technical defenses. So I would say there are 2 sets of defenses. The first set of defenses will be the technical defenses, which is, for example, jurisdiction. Jurisdiction, is a technical defense. Limitation, if the complaint is delayed and there's no justification, or if the notice is delayed and there's no justification, that is a ground, and that's a valid ground. Further, if there's a defect in the notice, for example, if the notice is issued to the wrong person, or it's for a wrong amount, or mentions the number and the details of a wrong instrument, all these issues become technical pleas for a discharge or an acquittal. On merits, we have to show that the check is without consideration, it's not a valid negotiable instrument, there is no debt, there is no liability, because without that, there is absolutely no escape. The third category is vicarious liability. So, as I said, if you're a company, then the individual directors are liable to be prosecuted and they can show that they are covered in the first proviso, and that's been settled in a classical Supreme Court decision. It's SMS Pharmaceuticals 2007, three judges bench very clearly set out that you can't make every director liable. There has to be a liability based on the individual role of the directors. Of course, this will not apply to people who are signatories to the check, who've signed the check, or the managing director of a company, as the case may be. So those categories apart, other directors have the right to be able to show that they don't have a liability. Now, while we are looking at this, I'm going to first start beginning with the issue on merits, because the technical issues are something which I'll deal with a little later. Now, as I said, there are going to be certain sets of concerns, certain sets of challenges. Let's look at the technical issues first. So the first issue is the notice valid? Does it contain the necessary ingredients? And that's how, as a defense lawyer, you're going to analyze it. Are the amounts correctly mentioned? Is it within the stipulated time? Is it addressed to the correct person? I've had cases where company A is the holder of the check, that is, the check is made out payable to company A, but company B files the complaint or issues the notice. Now, that's a very valid ground to say there's been no demand. Or otherwise, the liability arises in company B, instruments are issued by company C, and you can make out that breach that company C issued notices for a liability in a different company. Now, with these kind of examples and these kind of plethora of examples, we have a series of defenses. And then you would also consider the limitation for filing of the complaint. That's within 1 month. If you don't file the complaint within that 1 month period after the cause of action arises, which is after the time there's a failure to pay, the complaint will not be entertained unless there is a condonation of delay. Earlier, there was no scope of condonation of delay, and that delay requires sufficient cause to be shown. That is, you have to give a justification why you could not file it on a given time, on a given day. Given the technical nature, it's very important for the complainant to stick to the letter of the law, and the moment the complainant does not do so, it leaves it open for the accused to be able to initiate action and to be able to challenge the prosecution in an effective trial. But for that, as I said, I would say you'll need effective and in-depth cross-examination, but what I would call delicate cross-examination. Because the moment you run into a situation, let's say by way of example, where you admit the signature on the check, then it becomes very hard because you have to really establish the lack of merit in the consideration or the liability. So one of the defenses that's sometimes taken, if available, is that even the check is not properly signed by the person concerned. So there will be cases, for example, where a son signs his father's checkbook. The Bombay High Court, in Higangat's case, it's a 2008 appeal, said that this is not a valid basis for prosecution and set aside it. Now, apart from this, the question is, as I said, the discrepancy in amount, the discrepancy in date, the discrepancy in liability. These are also various issues that arise. When we come to dealing with the merits of the matter, we realize we are faced with a presumption against us. Now, this is a presumption of fact. It's a rebuttable presumption. That is to say, an accused can validly discharge this presumption by two mechanisms. The first mechanism is the accused can cross-examine and show the absence of the ingredients of the offense or liability. Alternatively, If the accused is not being successful, you will also set up your defense. So, by way of example, if a person is claiming money under one check and your defense is that you later paid the amount or earlier paid the amount and these checks were taken unlawfully, then the fact that you have filed a complaint with the police regarding stealing of checks becomes very important. That's part of your defense. Or if you paid and you can show from your bank transactions or correspondence that monies have been paid against a check which the complainant is holding, then that too is a very valid, very, very valid defense. The difficulty arises is having admitted the signature on the check, you're stuck because the Act mandates that presumption that the check is for discharge of debt or liability. And this business of discharge of debt or liability becomes very onerous. Of course, there have been cases, for example, the 2014 decision in Indus Airways, which is 2014 12 SCC 539. It's a very important decision because a person who had a transaction, the accused had a transaction, and the accused said, before the transaction could take off, we had informed the complainant that this transaction is failed, we don't owe you any money, please return the checks, there is no consideration for these checks. The complainant did not do it, and this did not even go to trial. The Supreme Court accepted this proposition and quashed the proceedings, and quashed the proceedings finally, though the High Court had declined to do so. However, I must add a clarification. After Indus came a judgment called Sampeli versus Irida. Now, Sampeli versus Irida is important because it distinguishes Indus. It brings out a clarification to say Indus was on its own peculiar facts. If you give a check for a debt in future, that is a matter of trial whether there was or was not a liability. And that was the distinction drawn in Sampeli versus Rida, which is the judgment of 2016, volume 10, SCC 458. Postdated checks was the case dealt with in Sampeli's case, and postdated checks is a very, very important element of negotiable instruments, litigation, and jurisprudence, because today, in all commercial transactions, that's what we do, don't we? We are always handing over post-dated checks for one or the other transaction. Now, as I said, there are issues regarding the manner in which a check is signed or prepared. So, a cutting on the check, what is called under the law a material alteration under Section 87 of the Negotiable Instruments Act, which is a mandatory provision, means that the check may not be a valid instrument. So supposing there's cutting out, supposing there's correction, supposing there's modification, supposing there's discrepancy, these become issues which are grounds of challenge to question the very validity of the negotiable instruments. Of course, people deny their signatures. Now, if the signature is denied, that's a little onerous because look, unless the bank has written back to say, and sometimes what happens is when you give a slip, and today remember, under the Negotiable Instruments Act, the mere slip of the bank is prima facie evidence that it is a valid refusal by the bank to honor the check because of lack of money or otherwise. So what happens is when the signature is at variant and the bank says the signature is invariant, people often take a defense that this is not our signature and we had not given this instrument over. Of course, this can be proved by another two mechanisms. One is by effective cross-examination, which is very imperative, and second, by leading a defense, by getting a defense, expert, for example, a handwriting expert. The only problem that we face in a practical terms is that courts are often reluctant to accept the veracity, the evidence of a defense expert, especially a private person who's obviously been paid professional fees. Of course, the other alternative is to, during that trial, request the court to send the check for forensic examination against admitted signatures and try and get that done if the court agrees to do it. Because if that can be done and the signature is found not to be that of the accused, then you have a fairly good defense in the case to show that it's not even signed by you and therefore not a valid instrument and no liability. Having said that, we must also consider that there are cases where checks are revalidated or where there are multiple notices. Now, if there are multiple notices, it is the last notice that will count, the last notice of demand. If that is to say, if there's presentation and representation, the last notice will count. Secondly, checks are often replaced. Now, people then have tended to file two sets of complaints. You can't maintain both complaints. You can maintain but the one complaint, and that is on the second bunch of checks. You can't have complaints on check 1, dishonored, returned, replaced with check 2. So check 2 will be the basis of prosecution. And if check 1 is the basis of prosecution, you can always argue that those checks are without consideration because they've been replaced by check 2, and that's been settled in a decision called Kumar Exports. It's a 2008-2009 decision. Now, these are some of the defenses which can be taken. All these defenses entail a deep study of the record, a deep analysis, a deep understanding. And just as in other criminal trials, though this is a summary trial, you have to know when to summon records in your defense, when to summon witnesses in your defense, because it is not always wise to summon witnesses who are going to perhaps give a fractured testimony or break down in cross-examination and who will not be able to justify or support your defense. That becomes perhaps more dangerous than not having a defense witness. You have, like other criminal trials, the same procedure of 313 CRPC, where you must put out your defense and explain what your defense's technical or factual or on merit are before you lead defense evidence. But apart from this, we must also look at the liability of directors. Today, under Section 141 of the Negotiable Instruments Act, persons in charge and responsible for the day-to-day affairs of the company or the trust or the firm or the society, as the case may be, are all liable by virtue of their status alone. Nothing more is required. The fact that they were directors when the check was dishonored, issued and dishonored, that's good enough because the liability is at the failure to pay. So how does a person in this category discharge the liability? As I said earlier, there are a number of judgments which make just the making of averments under 141(1) enough for a trial to ensue, whereas others say the three-judge bench in 2005, Nita Bhalla's case said, you don't have to have just a bald assertion. It has to be more than that. You have to point out who is responsible for what role, because what used to happen earlier and even happens sometimes now is that if there were 20 directors, irrespective of whether some were independent, some were sleeping directors, all of them were being prosecuted. Today, the clarity in the law exists that not every director can be prosecuted. And finally, relief has come in a defense arising from Section 149 of the Companies Act. Section 149 is a very important provision which excludes the liability of independent directors, which exclude the liability of nominated directors. So these people, the nominated and independent directors, can turn around and say, we are protected under 149. Of course, it is open to the complainant to show that they have acted in a manner which is not conducive to their existence and as an independent or a nominated director, because financial institutions, other companies who invest in corporations or partnership firms have their nominees on the board. Now, these nominees are there really to protect the interests of the person who's invested and are not in charge of or involved in the business. They're only there to oversee things, and they ought not to be prosecuted. But finally, the legislature has come to the rescue. There is a Delhi High Court decision, KP Balaraj, which has settled this. The matter is currently pending in the Supreme Court. There's an SLP and notice has been issued, but hopefully this will be settled. But that's the very valid and available defense. There are also now ongoing debates that are pending in various courts. I must share that with you. One of the issues is the extent of application of the CRPC and especially amendments like that to Section 202 of the CRPC. Now, this is an important amendment. This issue is pending in Phillips Carbon Black case in Joseph versus Phillips Carbon Black. This issue was left open. It's still pending in the Supreme Court. And the question really will be whether the requirement for recording, for having a full-fledged inquiry is applicable even to prosecutions under the Negotiable Instruments Act, though there's a summary trial and there's a special procedure. Now, if an inquiry is to be done, then it's not just an affidavit of the complainant, but witnesses have to be summoned. So this issue is pending consideration right now and will be evolved. I must share with you that in earlier times, in the year 2000, there were a number of challenges to the Negotiable Instruments Act in terms of its interplay with the Companies Act and the then BIFR, the SICA Act, the Sikh Industries Act, which is the relating to BIFR. So the argument there was that if the BIFR passes an order of restraint, can you have a prosecution because there is an inability to pay? It's not a failure to pay, but an inability to pay. Now, this legislation makes inability to pay not an offense, but failure to pay is the offense. So those cases were decided on their own terms. There was Kusamin God's case, there were Pankaj Mehra's case, they got decided. And now, after the SICA has been repealed and now that we have the IBC and the new Companies Act, there are also challenges pending that if there is a restraint order on operating the accounts of the company or an entity or of an individual, and a person is issued a check, can that check be made the basis of a prosecution? These are issues which are partly considered by the high courts and they have to be determined by the Supreme Court. And this interplay between these various legislations is very important. I must tell you, like in any other defense, like in any other criminal trial, there is the Negotiable Instruments Act cannot be read independent of the requirements of Evidence Act, though as I said, there is a mechanism for filing affidavits, but there is always the scope to cross-examine the witnesses produced by the complainant. Secondly, there is also an interplay with the CRPC as to the procedural requirements of CRPC, whether Section 202 or Section 251 or admission and denial of documents. And all of these ingredients can be used to create valid procedural defenses and substantive defenses. And that is what makes this law unique. Having said that, I must also tell you, it has provided a lot of scope for determination in magistrates' court and for young and old lawyers. And till there is still further amendments to streamline the law, I believe there will continue to be jurisdictional challenges. There will continue to be cases which require interpretation of not only the original words, but even the language of the amendments of 2018. So those interpretative exercises in court are going to go on. But till then, we have, as I said, a series, though limited, of valid defenses, and those are the ones to be looked at. Now, if there are any questions, I would love to answer the questions. Right. So there's a question by Mr. Himanshu Dhawan. What if the magistrate summons the accused without proof of service of notice within 30 days by just averring in the plain that it was served? Now, in such cases, it's a valid defense. You can even file a quashment to say, the only thing which is very important, and you must keep this in mind, is there is a presumption of service of notice, and therefore people can't avoid notices. Earlier, what used to happen was when notices were sent, people would say, we've not received it. But now there is the presumption of postal service if you can show that it's not been served. So, for example, let's say there is a notice which is sought to be served through Speed Post AD, and you can produce a record that you have not been served or that address is not your valid address, then you have a very good case for a defense. However, if the record reflects that you, as who were sought to be served the notice, has been evading service, and the postman's or the post or the courier service record that there is a failure to receive, and there are endorsement that there was an attempt to receive but a denial to receive, then that will become a problem for you. I must also add another issue. There's Varun Dhaval talks about thoughts on complaints instituted against company post admission of insolvency. As I said, the company remains a valid entity; it can still be prosecuted. However, if there is a restraint on operation of bank accounts and there are funds lying in the bank, then that cannot be a case of a failure to pay. That's a case of an inability to pay and a valid defense. There is also another very important thing which I must share, which is a settled proposition of law, another defense, which is now, sometimes it still comes up. If there is a company or a firm, which is company especially, which is the issuer, which has issued the check, and you don't make the company a party, in Anita Hada's case in 2012, followed in a 2019 Supreme Court decision, the prosecution will fail because the law requires the company and the person in charge and responsible to be prosecuted. If the company is not prosecuted, you can't merely prosecute the person in charge and responsible, and in such cases, prosecutions will fail. And because there is a period of limitation for the checks, because there's a period of limitation for the notices, these prosecutions, if they fail at the threshold, it is normally impossible, and complainants are then left to civil remedies. There's another question which I see when the company is liquidated under IBC. Well, the liability of the directors doesn't necessarily go away if there's a failure to pay in their term. Let's say a company is proceeded with under the IBC and it is liquidated. Well, then the liquidator or the IRP initially, and then the liquidator will represent the company, and the directors will be liable because of their failure to pay. They can always argue that as a defense that there were enough amounts available in the company and those amounts should have been used by the IRP to discharge the liability, and the IRP's failure cannot be attributed to them, but that will have to be seen on each individual factual situation. There's another question by one Mr. Pandyan, and if I may just respond to that, whether the complainant has to wait from the receipt of notice by the accused. There is a concept of once notice is issued, you can't really prosecute the day the notice is issued, but you can give it a time for a week. If you, of course, get the AD card back or the confirmation that service has been done, that's fine. That's the day. The date of service of the notice is the day on which you start counting your limitation for filing of the complaint or for awaiting the period in which money is not paid in filing of the complaint. But having said that, I must also point out that if notice is not received, as I said earlier, then the position has to be that you can say that there was deemed service within a reasonable time, within a week or a fortnight, and then proceed to file. There is a question regarding nobody appearing on behalf of the company when company is under liquidation. Can the matter be proceeded with? Yes. When the company is under liquidation, you may serve the official liquidator and inform him. And if he chooses not to appear, the prosecution will not fail because of his failure to approve, because you brought it on record that the company is now represented not through its erstwhile management, but through the liquidator. Right. There's a question regarding period of limitation to extend a multiple notices are sent. Well, actually, as long as if you have to present the check again and issue a fresh notice. So you can't have multiple notices necessarily legitimate. You can only have one notice on one dishonor, but you always have the right to represent the check within the period of its validity. And if let's say you present the check today, but you issue a notice, let it lapse, and then again present it after 2 months before the 3-month period of its terms, and then you issue a notice, the second check dishonored, and the notice will be a valid basis to launch a prosecution if there's a failure to pay. There's an interesting question that if a person dies, signs a postdated check and dies, what's the remedy available to the complainant? Well, the remedy to the complainant will then be under civil law and not under criminal law. You may seek to collect from the legal heirs on the civil side, but criminal liability is individual in nature. You can't invoke this. Okay. If summons are not being served, well, that's for the court processes to make sure summons are served. This often happens and this becomes a problem, and this problem will have to be obviated by more effective service of process. Sometimes you can even take dusty service or try and get them summoned through the local SHO where the person's office or residence is. Now, a question arises whether a check is issued as security and deposited without notice to the accused. I must tell you, there are liabilities in present and liabilities in future. If the check is merely a security check and not for consideration, then liability will not lie. But otherwise, even a check issued for security can be presented. There are cases where people say that having issued a check without complying with the terms of the contract, the dishonor of check prosecution will not lie. But my view is that that may be tenable in a civil liability. But here, when there's a special law with a special procedure, the provisions of the Negotiable Instruments Act alone will apply. A question is asked regarding the applicability of Section 173(8) of the CRPC. The answer is that will not apply. That's a procedure in police complaints and not here. However, Section 319, summoning of other accused, can lie. For example, supposing the liability of other individuals comes, but you also have to show that the notice should have been issued to them if it's a notice to individuals, or the demand notice is issued to the company of which this person is a director and officer in default. When there's a discrepancy between the version in the complaint and the version that comes out in evidence, that can definitely be to the advantage of the accused. It's for the accused how to take most advantage to show that the complaint itself is false and the improvements in the evidence do not bear out the complaint, and therefore the complaint should fail and the prosecution should fail. Now, I'm sorry, I'm also losing track of the questions which are coming quite fast. Whether independent directors are liable under the NI Act, Sujata Shirolkar, I've answered that. You can take the defense of Section 149 of the Companies Act, which exempts independent directors, nominee directors, unless they have not acted only as independent nominee directors. If they have colluded with or acted beyond their role as independent nominee directors, then they can definitely be prosecuted. Can an FIR be filed in the case of dishonor of check? That's a very important question. Yes, you can file an FIR. I believe there is illustration D to section 415 of the IPC. Kindly see that checks which are dishonored can also lead to prosecution for cheating, and that is a valid course. That's a parallel action that can be launched in such cases. Now, if a person, there's an interesting question, if a person retires before the check gets bounced, that person will have to show as a defense that they had no basis or no occasion to repay the money, though, because the person had been a signing partner at a point of time when the check was issued. But when it was dishonored, the person had severe ties with the partnership or with the company on whose behalf the check was issued, and that can be a valid defense. The mere fact that a board meeting has not authorized the issuance of a check may help certain members of the board, but will not necessarily help the managing director or the person who signed the check. Because remember, checks are signed in the normal of course by persons authorized by general or special resolution by companies to sign such checks. If that is done and is done for a transaction, it does not lie with the company to say this is not a valid issuance of a check. There's a question regarding the delays in such Negotiable Instruments Act cases. It's a very valid point. They should be done expeditiously, but they just linger on interminably. And sometimes the process of this prosecution for the accused or even for a complainant become worse than the punishment itself. Even if there's a clerical mistake and you've not mentioned 141 in the legal notice, you can always say that the directors, being persons in charge and responsible, were involved. The catch may be if you're alleging the ingredients of 141.2, which talks about specific collusion or specific conduct on individuals who are not necessarily directors, and that becomes a case where notice will become necessary. A question arises whether if a firm is merged with a company, will the company be liable to the partnership firm? Now, this is very interesting. There is no transference of criminal liability. So, even if the firm has ceased to exist, the individuals who were partners can be prosecuted. Right. Tasha Singh asks a question whether there's a presumption of notice being served in the registered address in case they don't serve. Yes, there is a presumption under the General Clauses Act and Section 114 of the Indian Evidence Act. Please see the illustration that official acts are performed in the normal course of business officially. However, that's a rebuttable presumption. You can always seek to prove that the notice was never served. If the signature on the check is incomplete or not properly done or not the correct signature, then the accused can show that it is not a signature or it is not a valid signature. But that is, as I said, an onerous defense to discharge. If part payment is made, a defense can be set up that this check is not for consideration. But nobody will accept that defense if for a check of, let's say, 1 lakh, 1 rupee has been paid. That's not going to be a valid defense, because the argument against you is going to be the check was still for discharge or liability, but we are only seeking to correct part of the amount. Of course, this is a criminal prosecution case. So it is a valid defense to say that certain instruments which are being used for prosecution have already been discharged of liability because payments against them already been made substantially or in part. There's no interpretation of the word substantially, but if the payment has been made, that may create a defect in the validity of the negotiable instruments. If the amount in the check is not the actual amount due, and he finds a complaint on behalf of other person, etc., if there's a default in the distinction between the complainant and the amount, and both suffer from inaccuracies, then that is a valid defense. Delivery of defective goods. If on a contract, the amount of goods delivered, the goods that are delivered are defective, and a defense is set up that though the check was issued in advance for payment against certain goods, but the goods were defective, then you will have to prove your defense that the goods were defective, and that is the reason you issued either stop payment instructions or did not keep funds in the account. One of the valid defenses that used to be available was people would issue stop payment instructions whether or not they had money. That was not accepted because that was also treated in certain cases as insufficiency of funds or enough to initiate a prosecution. However, it is always open, similar to Indus Airways case 2014, to show that the check was issued for a transaction which is fallen through or under which the goods given were defective, and therefore the check is without consideration. So, are there any other questions? Mr. Davani wants a question regarding what has asked about 251. Well, according to me, Section 251 has no 251 is a formality of framing of notice. It is not like a formal charge. It is a gist of the accusation, and it really requires you to be told that there is a check, the amount is to be mentioned, the details are to be mentioned, and this check having been dishonored and the payment not being made, you are liable for the offense. So that's the short issue under 251 of the CRPC. Yeah. The complaint is maintainable against the guarantor. Very much so. If the complainant if the check is issued by the guarantor, then you will prosecute the guarantor and not the person who's received the loan. In civil liability, you may prosecute both, but not in criminal liability. So, are there any other questions before I can get a exemption from personal appearance because I have to carry on to something else? There's a very interesting question I found on lockdown and COVID. So, what's going to happen on the lockdown and COVID when you can't initiate actions or issue notices? Well, obviously, in such cases, there will be large scale condemnation of delays because, after all, even if a check has bounced one day prior and you've issued a notice, you can't launch the prosecution within time. And perhaps the person can't access the bank and even make a payment. So, that being the position, the lockdown and its impact will be seen in the time to come. If there's an alteration of check, as I said, if there is a material alteration, you can argue that it's not a valid legal instrument, it's not a valid negotiable instrument, and those defenses have been taken in the past. The prosecution, of course, can be maintained if notice is only issued to the managing director, not necessarily to the company itself. But you can't just issue notice to the signatory and not to the company, not to the managing director, and expect to be prosecuted. So there's a question that arises: what if the accusers change and no fresh address is available? Now, in such cases, magistrates are justifiably going to be hesitant in issuing proceedings under 82 CRPC. But then you will have to do a little homework to see whether there is an alternate address or not, and if the last known address available to you, both from your records or from the records from the bank, because the bank account will have a record, and if the bank account has the last known address as X address, then that should be treated as the valid address for issuance of Section 82 proceedings. Yeah, so any other questions, if I may ask? Or can I get exemption now? Is there a liability against dated security checks? Yes, there is a liability against dated security checks because the question is really, are these security checks or are these uh, are these checks for consideration or are these just security checks without consideration? And that becomes very important. The complainant there's a question which comes whether if the complainant dies, can the legal heir prosecute? The answer is yes, the legal heirs can enter and prosecute on behalf of the complainant, saying that there was a valid liability and we will prosecute. And they can be replaced and brought in as complainants. If the AR through whom the complaint is filed is not available, then you can replace the AR. That was settled in the classic case of Associated Cements versus Keshwanand. I believe it's 1997 Supreme Court. Ankit Agarwal asked whether an accused is discharged in a complaint case in a Negotiable Instruments Act. That is an incorrect use of the term. There is no discharge. There is actually either he or she are not summoned, or there is a quashment, or there is an acquittal. Part payment after notice can be treated as a defense that there was an attempt to pay and inability to pay the rest, and that can be a mitigation, if at all. Sorry. If you don't have the email address of the accused during the COVID period, well, then you'll have to wait till you are able to send physical services. Though I must tell you, I believe courier services are still functional and postal services are still functional. The only question, which is a legitimate issue, is how will you go and post it? You can, of course, put it in the normal post bag. For that, you need stamps, etc. But courier services, I believe, are still functional. The approval of the resolution plan does not tantamount to settlement of NI Act proceedings, though it's binding because this is a case of criminal liability. The issue of criminal liability versus the IBC proceedings is being debated and I believe has not yet been settled by the Supreme Court. That will be settled, and that will be very material because, for example, in the context of people who've been prosecuted in hardcore criminal cases, people who've come in, the issue has arisen whether a company which is taken over in under the IBC, company A is taken over by company B in IBC. So there are certain statutes such as the PMLA where large-scale financial liabilities arise. So will these compensation and liabilities be imposable on the new company or the promoter company that is now taken over the company which was bought under IBC? So these issues will need to be determined completely, yet there are still debates and considerations going on. As I said, if the account is frozen or the account is blocked or seized by a court order, these are valid, credible defenses. That was the principle in Kusum Ingod's case. I would recommend that all of you see it. The notice under 138 and NCLT should be a distinct notice. They should not be a joint notice. That is always apt to be challenged as being defective, in part, not under NI Act, but it may not be acceptable under the IBC. Blank checks are a very important thing. So a blank check is like the endorsement in blank, which can be completed. The moment I sign and give somebody a blank check, I fill in the authority or I sign my signature, then under the Negotiable Instrument Act, the complainant can avert that he or she had the authority to fill in the uh, date and the details because that check was given with the authority to complete the endorsement in blank to the endorsement in full, and that can be done under the Negotiable Instruments Act. So if I can I have your can I now have I've done my bit. Any other questions, guys? Are there any other questions? other valid questions? There was a question regarding a court passing a judgment in the absence of the accused. Well, uh, ideally the accused should be present, because if there is going to be a sentence or otherwise, the person should be there to be present. But there are cases when people seek exemption for the purposes of conviction, though not for sentence. Of course, these cases are where the punishment is limited, and bail pending appeal is almost a matter of right under 389 CRPC. So, on the date of the award of the conviction, the person can seek exemption if there are special circumstances, but not at the time of sentence, because at that stage, you have to seek and get bail pending the filing of an appeal. I hope I've been able to answer most of the queries. If there are anything else, I'd request my friend Divyanshu to prepare the question in a format where similar questions are added, and then I will try and deal with all the other queries. If Mr. Sani asks, if the complainant dies, what will be the effect of the cross of the legal heirs? Well, if the complainant dies, the complainant's legal heirs will have to show liability. They'll have to prove the signature on the complaint. They'll have to prove the transactions, and they'll have to be queried on that. If they are not aware of the transactions, then they will have to bring somebody to prove the nature of the transactions. Because, for example, supposing the father is running a business and the son is in employment, then the son may not be aware of the business, so he can seek permission to bring in employees or managers of the business to show what was the nature of business transaction between the complainant and the accused. The fact that an agreement is not a legal agreement or not a valid agreement, or there is no consideration under the instrument, can always be a defense. A question arose, when is there a premature complaint? And I'm grateful to Mr. Rajat Jain that limitation, he says, he talks about the order of Justice Nariman extending limitation. Yes, I must point out, a premature complaint is when you file a complaint before the period for payment of the money pursuant to the receipt of legal notice. Once the notice of default has been received and the payment, and there's a period provided for payment, 15 days. If you don't make the payment within that, if the payment is still, that period is still to lapse, and the complaint is filed before that period lapses, that's a premature complaint. If a person is being declared a proclaimed offender and the person has no assets, you have to then trace them out, and they can be prosecuted, they can be sent to, in lieu of if discovered, they'll be sent to jail till they pay up the money or till they suffer the sentence. But there is a problem, because when people don't have assets, and people sometimes liquidate their assets so that there's no liability or no asset which you can get in the situation where somebody is absconded from justice and has become a proclaimed offender, and that does lead to a practical problem. So I'm now going to take your leave. Ladies and gentlemen, thank you so much. It's been a great privilege, and thank you so much for having me here. Thank you so much. Any questions, send them to our friend Divyanshu, and he will send them to me, and I will then try and answer them at a later occasion by email through his Facebook account at the earliest. Thank you so much. Have a nice day.